such as schools and other safe places, a victim suffering from an array of mental health issues may be hesitant to immediately bring forth a claim before the 12-month limitation for a myriad of reasons, which could be innately connected to the trauma inflicted from the experience. Might I add that this limitation is tone-deaf in relation to young children who may be victims of sexual harassment, but unable to immediately discern what exactly is happening to them at the hands of these perpetrators. So a 12-month limitation in this regard is undoubtedly unfair and short-sighted. In substitute of the proposed 12-month limitation, Girls Who Know Jamaica suggests that in keeping with the nuanced nature of sexual harassment and upholding the importance of mental health, the limitation period should be expanded to allow victims at least 24 months to bring a claim of sexual harassment. We believe that this additional 12 months will allow for more room to process the harassment while ensuring that not too much time has passed to instill doubt. Although there should never be a limitation on a victim's trauma, which may negatively impact their willingness to come forward, a limitation period of 24 months is a whole lot better than 12. With this being our final point, I would like to wholeheartedly thank you for your time and consideration.
Thank you for your presentation. Members, I now invite you to make your comments. I think you may want to say something. Senator?
I would prefer, Chair, to respond to an individual group and give them the opportunity to be heard. I just want to see clarity on 3 areas. You made reference to the word frivolous that is included in the bill. Are you saying that we must delete the word frivolous, or would you be prepared to substitute a definition for the word frivolous so that an individual can understand what frivolous would mean as it relates to the legislation? That's the first thing. The second thing, I would want to agree with you in terms of the definition for sexual harassment, where you made mention of the Barbados, the clause included in the Barbados legislation that says nothing in subsection 1 shall be interpreted as precluding a finding of sexual harassment where there's a single incident. So that means that it's not limited to what is defined or contained in the legislation, if that's what you're saying. And the third thing, Chair, the group made reference to Section 43H in regarding a business internal policy. Now, I want to be able to understand and appreciate is that you would prefer for a business to have an internal policy, not only a policy statement, but a procedure in which persons raise allegation can be addressed. And I take note of your comment because I believe a previous group had made mention of an employee in the organization who may have been exposed to an advance by persons external to the organization. In this case, you made reference to a nurse and a patient, but not necessarily an employee, an employer. So you're saying that your preference or your like would be to have some sort of a commitment that an organization would be having a procedure or a policy that deals with the external persons, customers, persons who engage in business externally with the institution in order to protect the employees. That's what you're saying?
Yes.
All right.
Can I comment?
Oh,
You want to
go ahead?
She'll comment on the first.
Thank you for your comment, Senator. As it relates to the question of frivolous, we think that word by itself could have the effect of causing doubt on a victim's mind, and doubt is already coming from other factors. She's or he could be thinking, no, it wasn't that bad. Maybe I'm overreacting. Maybe I should just suck it up. And that's not what we want. I think that's contradictory to the purpose of this bill. What I'm saying is that the act shouldn't be another cause for doubt or another reason why a victim decides that she or he is going to just sit home and take it. However, I understand that I understand the Parliament's intention of not wanting to flood the tribunal. So I would say if the word has to stay in there, then there needs to be some form of clarification. There needs to say, or definition rather, to say that a frivolous complaint is one that X, Y, and Z, so that a victim can look at it and say, well, my personal complaint doesn't fit into this box, so I still stand a chance of having justice.
Thank you for your comment. So our proposition is yes, because should we limit the scope of sexual harassment to only between like employee and employer? That's too limiting of a definition, because it is a clear reality that customers, patients, outside persons, external persons do sexually harass employees and people who work in the business. So we are proposing that businesses create their own policies and strategies that would include outsiders, how to handle situations where an outsider has committed sexual harassment to an employee. Thank you.
Last comment, Chair, just to indicate, because I take note of the fact that they had represented that the workplace since COVID-19 would have shifted. And so there was a suggestion for the purposes of the legislation to define workplace so that it does not appear as the workplace is only the place that you go to, but in this case, in terms of a physical space. But in this case, it would have been widened. So a definition of the workplace was being suggested.
Well, actually, it was a definition of what sexual advancement includes, so that technological advancement would be. So even in the workplace, you have your emails, you have your means of communication, and we think that sexual harassment can prevail in those situations too, and we would like for it to be explicitly stated in the bill that if an employee or an employer makes an act that would constitute sexual advancement through technological means, then it should be covered under this bill.
I don't know if sexual advance, the definition E, would satisfy.
No, we're saying we understand that that's a catch-all, but we would say it would be more appropriate maybe if there's an explicit.
If it's explicit?
Yes.
Okay. Thanks, Chair.
Any other questions? Yes, MP Bromder. Member Brownberg, remember we have the Hansard reporters there, so it may be useful for you to remove your mask when you're speaking, or for more clarity so that they can record accurately what you're saying.
Thank you very much, Madam Chair. I'll make sure I speak a little slower so it's clearer. I'll enunciate, yeah, because this thing here is real. I was talking about the clause 25(2) that was raised, and I thank you for raising it. And it is something I'm not sure we had agreed on what is an appropriate time frame. It's clear that 12 months is too short. I still believe that 24 months is still too short. And I think that that is a matter that we are going to have to look at, Madam Chair, and agree on what time frame would be reasonable, given all the considerations that are important. One last point, which is the one around public education, and I hear you saying that there should be a mandatory prevention, intervention, education, and public education and awareness. And I want to thank you for that suggestion. Every time a bill comes before us, that has always been a preoccupation of mine in terms of exactly how we deal with the public awareness. Because often we seem to believe that just taking it through the stages and the discussion in Parliament is sufficient public awareness, and it certainly is not. So I am happy to hear you raise and put on the table an idea that would allow for a much more precise and clear way of moving forward with public education. So thank you for that.
Do you wish to make a comment?
No. Thank you for your time. We appreciate it greatly.
Madam Chair.
I will take Mrs. Georgette Grant, then Senator Longmore, and then Mr. Whittle, MP Whittle.
Thank you, Madam Chair. I just wanted to follow up on what Senator Gale said in relation to the clause 443H that was mentioned in the submission. And the essence of the mention in the submission was that the internal mechanisms, the stipulation of the use of internal mechanisms, especially in a case where the perpetrator is the employer or someone in a position of power, would put the victim at a disadvantage in that these internal mechanisms can be manipulated. And I just want to point out that as it is now, clause 25(4), subclause 4, and subclause 5 make provision for such a situation where the aggrieved person can go directly to the tribunal once they can show that they are likely to be prejudiced in any way if they were to utilize the internal mechanisms. So I just thought that you should know that. I don't know if it changes your position in any way.
Thank you. We understood that, although it's in our written submission, we realized that between the periods of July to now, which is why we didn't make an oral submission concerning that. Thank you.
Senator Longmore.
Thank you, Chair. Let me join also in congratulating your group for making your submissions, really very well presented. I wanted to just reiterate one or two of the points that Senator MP Brownberg had also mentioned, but just to go back and remind us that the whole time frame issue, and I say this and I bring this up because of the level of importance of this in this bill. It is very much recognized that the mental health impact can be years in coming and can be years in lasting. But we also need to recognize that significantly persons are actually victimized because they are suffering from a mental illness. And therein lies another dimension to the reporting process that I think also needs to be considered, and possibly something else that needs to be recognized within the structure of the bill itself, where persons who are particularly vulnerable to being victims are also preyed upon. And so that in and of itself is something to consider in terms of the mental health implications of sexual harassment. We remember the famous happenings around the last discussion, around the time frame in terms of you know, what came out from that. But suffice to say that it is the opinion was entertained that once the person could prove, it is a burden of proof, so to speak, that it should be, that is one of the considerations, that the person should be able to make a report. So there is the consideration that there isn't a time frame. Some jurisdictions have 7 years, some have 2 years, and we actually were entertaining, some have 3 months, but we actually were entertaining that once the person could prove, even it be years ago, that they be allowed some sort of hearing to recognize their concern. The other thing that I just wanted to bring to our attention to is the terminology frivolous. Recognize that there is a propensity at times for persons to take advantage of the provisions of the bill. And that therein lies one of the safety mechanisms that we're hoping to employ. Also recognize that frivolous to you may be very significant to someone else. So it is a very precarious position to try to approach. And so I think the approach would be to have a definite definition of what entertains that. And in so doing, I would suggest that there be significant consultation with mental health experts, because it is a subjective process of the victim that needs, I think, to be considered in such a definition of frivolous. Thank you, Chair.
Thank you. We take your point about the definition of frivolous. We understand that the bill needs to implement some method of safeguarding it against abuse court of the tribunal, but still we realize that some victims might see the word and run away, and that's definitely not what we want. We're pleased to hear about the mechanism you mentioned about once there is a proof that the person should have a right to a hearing, then he or she will be allowed. So thank you.
Thank you. MP Witter?
Thank you very much, Madam Chair. In your presentation, I heard you use the word sexual advance. I want to find out if you regard of sexual advance in any case as sexual harassment, and whether or not you consider sexual advance to a particular degree that would cause it now to be regarded as harassment.
I'm sorry, we can't. It's very difficult to hear you. I think I heard him. So are you asking to what degree would an advance be considered sexual harassment?
Yes, because, yes.
Well, we would be in a position where it would reach the point of sexual harassment, one, where it is an unsolicited advance, and where it is a continuous situation where it is continuously unsolicited, where I don't like you, you're continuously emailing me, lewd emails, calling me, lewd calls, against my own consent. That is where the line of sexual harassment would be drawn, consent. Thank you for that question.
Okay, Senator Rodriguez Campbell, and then MP Jamaica Davis.
Thank you, Madam Chair. I want to bring it back to a response that Ms. Grant gave about 25.5, where it talks about it goes back to where the young lady, Senator, about Section 43H, where the person has to go through the mechanisms within their own organizations. And then Ms. Grant mentioned that this section in 25.5 you can go directly to the tribunal. That if you can prove, if the victim can prove, you know, what's in A and B. What I'm saying is that puts, am I understanding you clearly? Because my reading of that puts a burden on the victim, which I think we don't want to do. So, you know, what the young ladies, what the document, Girls Who Know, spoke about is the fact that that mechanism that is in the organization could be prejudiced against the person, the victim. The victim could feel as though they can't go through the process. And the response there where we're saying then it's on them to prove to the tribunal, isn't that considered a little bit of a burden on a victim to do?
I don't think so, and I'll qualify it this way. It is, the stipulation is that before you go to the tribunal, as a first measure, you should exhaust the internal mechanisms that are in your organization. As we know, there is this many times uneven balance of power. So if it is that the person who is the perpetrator is one that is likely to influence or interfere or manipulate those internal mechanisms, then you can go to the tribunal and indicate these internal mechanisms exist in my organization, but I don't feel safe to use them because of this. And as it is worded here, certainly based on how the interpretation, the tribunal is to accept that claim. So I don't think it puts an unnecessary burden. It's just a simple stating of what exists and for the tribunal to act on that.
But could it be worded to, because what you're saying, the way it's worded here, subjectively, I wouldn't have interpreted it as such. So if I were sitting on the tribunal and the bill here says, provide evidence to show, that for me means that I have to show evidence versus you're saying the person just goes and says X, Y, and Z, and then it happens.
All right.
So if we can word it in such a way, because when I read the bill here, it is more than what you're saying. That's my interpretation. So it's very subjective.
All right, there are two things. Just so we're clear, there are two things. A speaks to the fact that you're going to show that if I use these internal mechanisms, given what exists, my rights are likely to be prejudiced, and so I'm coming directly to you. Please hear me. That's A. B saying that if no mechanisms exist at all, you have to show it. Show it to me, because you're supposed to exhaust those before you come here. But if there are none, show to me, prove to me that none exists. So whether it is that you're going to show that the policy statement that was provided does not detail, or whatever, they don't have any such policies, then these don't exist, and so I want to come directly to the tribunal. So the two qualify or speak to two different things. A is a situation, you're going to speak to prejudice, please hear me. B is a situation that no internal mechanisms at all exist, so I'm coming directly to you.
Can I just add to that, B would relate to clause 4, paragraph, subclause 3D, which speaks to the establishment of internal mechanisms in a workplace. So the evidence there is for you just to show that these mechanisms do not exist, hence you are requesting leave to come directly to the tribunal. So it would relate to that particular provision.
Okay, thank you. Jamaica, MP Davis.
Thank you, Madam Chair. I really was impressed by the presentation, and I point to your discussion surrounding Section 25.2. I quite agree and understand the point being made about the 12-month period, but as an example, you cited young children. Now, when we consider that this bill not intended to cover those situations, Was that part of your contemplation, and would it change your view? And as a follow-up, would you have a recommendation of a time period?
Thank you. Sorry. Thank you for your question. We base this consideration of young children or younger children because the bill's intention is to protect those in safe spaces, vulnerable people in safe spaces. One of those safe spaces would have been schools, and younger children do attend schools, and unfortunately enough, we know about instances where teachers take advantage or sexually harass young children. The point that we wanted to bring across, which I know you understand, is that sometimes little children don't fully understand what's going on at the time. They trust these teachers, and when a teacher is good at manipulating a situation enough, the younger child will believe that what is going on is okay, but a while after, you tell your parents, they're wondering, what is this my child is telling me? So that's where that consideration came from. Institutions such as schools, the younger children do attend those. So our recommendation was that we implement a time period of 24 months instead of just the 12 months, so that we take into account instances where it's not immediately discernible that you were sexually harassed.
You want to follow up?
To clarify, yes.
Okay, good.
In relation to children, we have the Sexual Offences Act as well as the Child Care and Protection Act. This is not to say this bill. When I said earlier that it does not contemplate children, what I meant was in relation to your example spoke to just young children. I wondered if you had contemplated any other instance in relation to the time period. Remember, you spoke about 25-2, and you said in relation to young children. I just wondered whether there were other factors at play.
I aforementioned in my part of the presentation, was that before I even mentioned young children, it was just general. I was speaking to mental health issues, which range from younger children to very old adults. So that consideration was made knowing that the bill primarily focuses on teenager up. You understand? So it wasn't, I didn't mean to restrict to younger children. Yeah.
Chair.
I did ask about the recommendation as well, Madam Chair, whether there was a time period that would be recommended. If you're opposed to the 12-month period, is there a time period that you would suggest or recommend?
I'd say the 24
I'm sorry, I didn't hear. I'm sorry.
Oh, I'm sorry. The 24 months.
24 months. Thank you.
Right. I will take MP Sibley's and then Senator Longmore. Huh?
This is just a footnote related to yes, that with respect to children, remember we're also looking at the Child Care and Protection Act, and a lot of what would relate here is specifically addressed there. So if there's a perpetration of that nature against a child, there are provisions in another legislation for that.
Okay, thank you. MP Sibley's.
I want to thank you also with my colleagues for making your submission. Section 39(2), where with regards to a fine not exceeding $1 million, I'm trying to understand in what way are you thinking, you're suggesting that it will discourage persons, because it says not exceeding. Therefore, 1 million is the ceiling.
Thank you. We understand that by virtue of the words not exceeding, the fine wouldn't be able to pass $1 million Jamaican dollars, but still, $1 million Jamaican dollars would be a lot to face for a lot of victims or just a lot of people in general. So, and we understand that, you know, the tribunal will use its discretion, but an average Jamaican reading that provision would fear that it doesn't make sense for him or her to seek justice, because if the tribunal thinks for any reason that they're lying, then they could be faced with up to $1 million, which does mean that they can definitely be faced with $1 million fine.
So, a follow-up question. What would you suggest, your group would suggest, in terms of what the mischief this section is trying to address, that the legislation is not used as a sword, but it is used as a shield?
Well, when I spoke about that in my presentation, I was comparing it to the penalties that a perpetrator who was found guilty would face, and that, in my opinion, is much lower than the $1 million fine. So I'm not sure what the best fine is. It could be set at a lower standard, because we do understand that the Parliament needs to protect the use of the courts, the tribunal, and that there are some persons, unfortunately, who will try to abuse the court processes or the tribunal processes. So we're in no way saying that Section 39 should be scrapped, because there definitely needs to be some provisions to protect the tribunal. But we're saying that in comparison to the penalties faced by perpetrators, we'd recommend that it's lowered a little bit. Pardon? I can't hear.
All right. MP, you wanted to, MP Sibley, you were finished? Yeah. All right. MP Whittle, you wanted to make a comment? Oh.
Just asking what was she said that the penalty for the perpetrator is much less.
Yeah, because based on what I've seen in the bill, it's...
So you are suggesting that it should be in keeping with that? Because the member was asking, what do you suggest?
Yes, and I said I'm not qualified to make the suggestion, but I would want it to be in comparison.
That's what I'm asking.
Yes, definitely. In comparison, the risk should be worth the reward, is what I'm saying.
Yes.
So it cannot be that the perpetrator gets a slap on the wrist, but if for any reason I am deemed to be lying, then I have to find $1 million maybe to pay for something that I... Yes. Thank you.
May I just say that we have a problem, you see, with fines. Now, there's a maximum fine. And to the extent that the person makes a complaint and they truly believe it, it may not exist, but they truly believe it, the likelihood is that that's a good defense. In other words, if they really believe that a person was sexually harassed, then quite frankly, I can't see the tribunal saying that even though you truly believe you are sexually harassed, it's a false complaint. That's the first point, okay? But this basically is to prevent this so-called frivolous complaints. Because if a person maybe feel that, you know, this man is big and behaving like he's some big popular musician, politician, businessman, and so on, and then comes up and make a frivolous complaint, it is meant to prevent that sort of frivolous complaint. This is why, even though I agree with you that we may need to assess what frivolous means, you're looking at a situation where, yes, the alleged offender may well have made a pass, for example, and you take it to be sexual harassment, but when you look at it objectively, it looks like a frivolous complaint. And that is for the tribunal to make a determination. But one doesn't expect that if you're found guilty, the alleged victim is found guilty, that a tribunal would impose a fine of $1 million. You get me? In other words, it's a maximum fine.
We understand that.
Right. Now, in all sincerity, there may be some alleged victim who are deserving of the $1 million fine. And the tribunal will have to use its discretion in determining what is the appropriate fine. Okay?
Thank you, Mr. Chuck. Ms. Georgia Grant, please.
Minister, I just wanted to say, because what I picked up from what you were saying is that the perpetrator is not subjected to the same $1 million as somebody who would make a frivolous complaint. Is that correct? That's what I was getting from what you were saying. And I just wanted to point out that this, as it is now, this $1 million is $1 million across the board. It's $1 million for everything. And also the clause 34 that speaks to the various awards the tribunal can make. It says in subclause 4 that when a tribunal makes the award, if the respondent fails to comply with the award, that person will be subjected to the same $1 million. So it's the same fine across the board. So I don't agree that it's an uneven playing field. There's parity all around.
Well, the penalties that I was making reference to was where it says if the tribunal agrees with the complainant, then the penalties that could persist include reinstating the complainant, paying for humiliation, I believe, things of those nature. There wasn't, in that section, there wasn't any mention of any fines as opposed, other than, I believe, punitive damages.
I have a comment from Mr. Chuck. I understand that the fine is a discretionary fine. It is to prevent false claims. But there are a lot of situations where women and men make claims for sexual harassment or even sexual assault, and they are found, they have a strong claim, they have a genuine claim, but the tribunal finds that the claim is false, or they rule it as false. So $1 million fine for somebody who was genuinely sexually harassed, but the tribunal labeled it as false, could be seen as something that is it's heavy. It's a heavy fine. Imagine you are sexually assaulted, and then all of a sudden, sexually harassed. Imagine you are sexually harassed. You bring it to the courts. You don't have enough evidence to support your claim, and then all of a sudden you have $1 million fine on your head on top of the trauma that you're suffering. So I can understand the point of a discretionary fine, but for it to be $1 million, it's kind of heavy.
But bear in mind, the fine is meant to be a deterrent to avoid frivolous complaints. So if you make it $5, then anybody could say, it doesn't matter, make your complaint. If it turns out to be false, you only pay $5. You see the point?
No, I understand,
Right.
I understand completely why it is $1 million, why we need fines, why the fine exists,
Yeah.
but I still believe that $1 million fine is excessive.
No, but the point about it is, I don't think it matters if you put $10, 100,000, or $500,000. The idea is for it to be a deterrent against false complaints.
But
So what I'm saying is that the $1 million is the maximum. In other words, I would never expect a tribunal in the average case to impose a fine of $1 million.
In fact, we can't say that.
No, but I'm not denying that, and I accept that there might be appropriate cases. There might be appropriate cases where the fine of $1 million is appropriate because it is clear on the evidence that this complainant meant to destroy the reputation of the person against whom she or he is making the complaint. I understand that. And if it is clear, you can see where the fine would be definitely quite hefty, because based on the evidence, it is clear that the complainant intended to destroy the person who is the alleged offender. But if you have the average cases where a complaint, it turns out that the victim genuinely believed that he or she was sexually harassed, and it turns out that the tribunal does not agree, I don't expect that the tribunal is going to impose a hefty fine. You see the point?
I understand that, but as well, the tribunal is very subjective. It's case to case, judge to judge, so we cannot actually say whether or not a judge would impose $1 million fine. Because it could be a case where it seems like it's false, the tribunal doesn't agree, and then there's $1 million fine on the traumatized person's head.
I see the hands, Okay. I will take Senator Rodriguez Campbell and then MP Brownberg, MP Tamika Davis, in that order. Go ahead.
Thank you, Madam Chair. Minister Chuck, I agree with you that it has to be a deterrent, but I understand where the young ladies are coming from. The tribunal is going to use a subjective measure to decide whether or not to impose the fine. And while sitting here, we cannot see a rational tribunal, putting a fine of $900,000 to $1 million on anyone. We cannot sit here and be assured that that will never happen. And I think I share the concern of the representatives from Girls Who Know Jamaica, in the sense that if you sexually harass someone, the bill says the fine should not exceed $1 million, which is the same as a victim or a possible victim would face. So basically, the fines are equating the two things. And I think that is where the problem lies. So in my mind, because the deterrent has to exist, so if we're keeping the $1 million as a deterrent, the fine that a perpetrator has should be bigger than that then. Because we're leaving it's a subjective matter for the tribunal. No, but I'm telling you how I'm interpreting it. So I would love if that's not so, because the tribunal has it here where they can charge $1 million. We cannot rest assured and say they won't.
Okay, so what I'll do, I will take MP Brownberg, then MP Davis, and then I will invite the technical team, someone to make a comment after you have made your, and Senator Longmore, and then I'll invite the technical team to make a comment. So, MP Brownberg.
Thank you again, Madam Chair. I just wanted some clarity, because how I understand the point being made is not simply that if a false complaint is found, that there's a possibility of up to $1 million fine. It is also against the background of this idea of a well-founded case, which is not frivolous or vexatious. And when you made the point, I thought of both of them together, because if the issue of what is well-founded is clear, and therefore this idea of frivolous is not there, then it will make a difference in terms of a case that is found to be false or is declared to be false. I accept, Madam Chair, the concern, because there have been cases that have been the clear experience of the victims, and they have not been able to make a case that could be heard and and not thrown out. And yes, you have to ensure that there are deterrents, so individuals are not just making cases and flooding the tribunal with cases. But the truth also is that a balance has to be struck, so that an individual with a case is not afraid that someone might believe the case is weak. It is thrown out, it is found to be false. And then here I am facing a fine of possibly up to $1 million. And I think that the concern is a real one that we need to take into consideration.
Thank you, MP Davis. I'll now take MP Brownberg. I'll now take MP Davis and then Senator Longmore.
Thank you, Madam Chair. I think we just need to read again section 39.2. It says a person who contravenes subsection 1, which is a false complaint, commits an offense and shall, on summary conviction in a parish court. So it is not the tribunal who is going to make this imposition, and it is upon conviction. So it tells us that this matter will be brought before the parish court, heard before a competent judge, who then makes a determination and then imposes a fine. It is not the tribunal.
Doesn't change the point who makes it. Doesn't change the point.
Upon conviction.
It's a single person who is going to decide on that conviction.
Senator Longmore, and then I will ask Mrs. Celia Brown to
Thank you, Chair. And I think what we're seeing here is a demonstration of the subjectivity of sexual harassment and the subjectivity of how some of these things are interpreted by different individuals. I think and you have heard me in other forums, Minister, where there's a great concern for me in drafting legislation, especially of this nature, where it comes on to the mental health impact that it has on potential victims, where there is not much consultation with the mental health experts in terms of how you come up with the consequences and the recognized consequences thereof. What we're seeing is a perception of the crime against the victim versus the victimization of someone via using the laws that we're laying out. The fact is that just as how you can have a victim who is actually harassed, you can have a victim in the sense of somebody being blamed for harassment and their reputation being ruined because somebody decides to do this. And that is a real other victim. Now, we have to recognize that there is a provision in the Act at 43 where the minister, by order published in the Gazette, subject to affirmative resolution, amend any monetary penalty prescribed by under this Act. So there are provisions where circumstances that are unique to the case could be presented by the competent personnel to say, look, this penalty needs to be reduced, this penalty needs to be more, etc., etc. But we have to strike a balance because at the end of the day, we have to protect all potential victims. And so that is why I have to also still reiterate my usual point of the legislative process consulting and getting the real persons who have to determine the extent of the damage to the potential victim or victims. We have to recognize that somebody sending a lewd picture to someone may see it as some act of joviality or maybe even flirtation, whereas someone may take very significant offense. But the only person who can determine the extent of that damage is someone qualified to evaluate how that picture impacts that person. And so we have to also recognize that there needs to be provisions in the law for that to be provided for potential victims.
Thank you, Senator. Mrs. Celia Brown?
Just to add, Madam Chair, that we have to remember that when we speak of a frivolous claim in law, it's usually a claim that has no merit whatsoever. And it will be based on the evidence that is brought before the tribunal. They will determine whether or not this claim is frivolous. So, I mean, I agree that we may need to change the language because of the type of bill that we are dealing with. That type of provision is usually necessary. When you speak of a vexatious claim, it's a claim that is made for the purpose of injuring the reputation or character of another person. So maybe we can tweak the language because of the nature of what we're dealing with. But I think those provisions would still be necessary, as Senator Longmore was saying, to create a balance as to, between somebody who makes a complaint, and maybe it may be quite in their right, and somebody who you may be issuing a complaint against, and it really may be frivolous or vexatious. All right?
Thank you so much. I want to thank the team, Girls Who Know, for your presentation this afternoon. And
thank you for having us.
yes, and we will certainly take into consideration the points you have raised during our deliberations. Thank you so much. You're free to leave. Yes, let's applaud them. Yes. Yes, and you can stay if you want to hear the other presentations. I'm going to ask the staff here to just sanitize the area here in the middle. The PSOJ team, you can remain where you are if you want to make your presentations from where you are, or you can sit in the center aisle. If you're not going to move, then I would invite the team from the Jamaica Tertiary Education. Once the area is sanitized, you can sit there because you're a bit to the back. Okay? All right. So, so ladies and gentlemen, representing the PSOJ is Mrs. Marianne McIntosh Robinson, Mrs. Maya Johnson, Mrs. Patricia Francis, Mr. Gavin Goff, and Ms. Greta Bogues, who is the interim CEO of the PSOJ. We have their written submission here, which should be in your files. And after their presentation, we will hear from the Jamaica Tertiary Education Commission. So at this, Ms. Greta Bogues, will you, each representative here will be speaking?
Madam Chair, Mrs. McIntosh Robinson will lead the presentation. So I'll just do the introduction and she will lead and we will join as necessary. Because we do recognize that we have 15 minutes to make the presentation. We're conscious of that.
All right, so you can proceed with your presentation and welcome. Good to see you here.
Thank you very much, Minister Grange, Chairman, members of Parliament, senators, distinguished ladies and gentlemen. On behalf of the PSOJ, we're really very delighted to be given this opportunity to present our position with regard to the sexual harassment bill. You have received our submission and we have outlaid approximately 11 points that we are going to be looking at. What we did is that we have gathered within the PSOJ what we would call a multi-sectoral and multidimensional team to review the bill. And what we wanted to make sure as we go through the bill is that we were not alienating anyone in the bill. So as you listen to the various points that we will raise, and some of them have actually been raised by the previous group, we want you to take that also into consideration. The Minister has already introduced the team, and the team is being led by our Vice President, Maria McIntosh Robinson. So, Mrs. McIntosh Robinson.
Thank you very much. Thank you. Good afternoon again, everyone. Take off my mask. Good afternoon again, everyone. Thank you for having us here to contribute to this very important bill. So I just wanted to first share that our submission is really centered in 4 sections. The first one is really around the theme of definition and scope. And we'll talk about it a little bit, it's in the 7-page submission, but it's really around points like we should be as neutral and dispassionate as possible. We'd love to suggest increasing the scope to not just be the workplace. We see this really in the instances where this has happened as a violation of rights with health and safety concerns. And we also want the consideration to be given for horizontal and vertical relationships. So we do want to expand the scope beyond workplaces to domestic household working situations, education, sporting activities, property relationships, exchange of goods and services, and churches. And the bill already contemplates a portion of this, so it's just where we can tweak. And we also would like to discuss the actual definition to include things like remarks. We talk about sexually determined behavior versus just advances, the environment, things like posters. So that's around definition and scope, and the details are in here. The second theme in our submission relates to the process. And within that, there are really two subsections. One is around the makeup of the tribunal. So we really want to suggest potentially highlighting more qualifications, beefing up a little bit in terms of what the minimum qualifications are. We also have a point about it not being just about mediation, but truly adjudicating on these complaints. I think it was mentioned earlier, training is key. We note in here that there has to be harassment training, gender awareness and sensitivity training, diversity and inclusion training, and intersectionality. We agree with those points, but we also, and that's for everybody, but we also think it should also include mental health, and we hear Senator Longmore speaking about that. We do agree that this should play a very prominent role in the makeup of the tribunal and this process going forward. We also thought the act should speak more about the criteria for selection, how the performance will be monitored, the turnaround time on cases, and as it relates to the 12-person tribunal, while we do like that it says how many females, again, we think it should be gender neutral. It should have, say, an equal number of male and females of a certain amount, and then the remainder can be determined. So that's around the makeup of the tribunal. In our submission, we also speak about the process for the complainant. And in here, we had quite a bit of discussion earlier about the language. We also have specifics in here. And what you'll see from the submission that the entire working group at the PSOJ did is we suggested drafting language, because we know you get a lot of submissions and you have a lot to read through. So we also put specifics in there for consideration. Physical access to the tribunal is another theme or point. You know, there is a western section of the island that may have difficulty traveling to the eastern, so perhaps an outpost or another location there using, and we can also be using technology as well, okay? And then the training, we do agree with the point about training in the workplace and public education. While this bill may seem very obviously needed to us, that we have an entire country that would need to be sensitized to what really is this and how to use it appropriately. We think this is pretty cutting edge, actually, though needed, and we welcome it. The third of the four themes, Chairman and Committee, is around the statute of limitation, and I will leave the answer. It's in the submission about what we're recommending, but our submission, as you know, is very specific. And we give specifics around not just drafting considerations, but what we would recommend as the private sector of organization of Jamaica. And the final theme that this submission has is around the powers of the tribunal, really around how awards are given. We believe that we should consider specifying where appropriate and limiting the awards. So whether it's a letter of apology, the greater of 2 million or 2 years of salary, we just want to make sure that this tribunal is very clear. It's not an unlimited award from a private sector standpoint. Okay, so those are the four themes. If I just take you through very briefly in terms of our submission, just to sensitize you to what we've submitted here. On page 1, and we do specify where in the legislation or where in the act, the draft bill, we're speaking about. On page 1, we talk about the definition, and this is in part 1, section 2, We also have part 3, which is the forms of sexual harassment. In the definition first, staying with part 1, section 2, we have on the right-hand side what we're recommending. We believe we could expand the definition to having 3 parts. 1, to say that it's unwelcome sexually determined behavior, such as physical contact or advanced, sexually colored remarks, showing pornography, and sexual demand, whether by words or actions, etc., etc. I won't read verbatim, but we have in there what we're suggesting. On the second point, unwelcome sexually determined behavior in exchange for a benefit or to prevent a detriment. And the final point is just the environment. So that is what we would suggest for consideration in terms of expanding the definition of sexual harassment. In terms of the scope of the law, on page 2, if you look at part 3 of, this relates to part 3 of the bill, but we, on the rightmost column, we are recommending that the scope should actually be unlimited. But if we want to limit it, we think we should at least emphasize specific settings, namely workplaces, institutions, tenancy, churches, public transportation, so buses, taxis, depots, clubs and associations, sporting activities, vendors, and receipt of goods and services. And as I mentioned, the bill in its draft state already contemplates quite a bit of this, so it's just consideration for being more explicit for other settings. And then the other point around the language comes out in part 27, section 1. We discussed it with the earlier group, with Girls Who Know, and this point about frivolous and vexatious. And as I was listening to you, I realized the lawyers in the room, frivolous actually means something from a legal standpoint. But for our working group, I must tell you, everybody's zeroed in on that word. So we do agree with the suggestion made here that perhaps for this bill, given the sensitive nature, that we consider using a different language. We have here to strike out the language, but we are suggesting in another instance with respect to the tribunal and injury, section 34, part 2, that we could replace it by saying emotional injury may be considered by the tribunal in awarding of damages. Again, this is just for consideration. So that's theme 1. Moving very quickly to theme 2, that I mentioned earlier. If we can go to page 4 of our submission, in part 4, which is around the designation of the authorized officer. Again, we do believe that the minimum qualifications of being female or an experience in labor relations and gender affairs is insufficient to ensure understanding of sexual harassment matters. We also do say that the Act does not specify the criteria, the selection process, how we're going to monitor the performance of the tribunal, how we're going to communicate with the public. We believe, given the nature of what we're discussing, the communication with the public is going to be so important. So we have on the right here what we suggest in terms of the training, which I had mentioned earlier, and we think someone with mental health training and or expertise should really be a part of the tribunal. We actually think you should specify that. We think all members should be non-partisan, and we think that the Act should be, we think you should revisit the requirement for 4 mediators. Perhaps 4 mediators is fine, but should we have more than that? Because again, we don't want to focus just on mediation. This is not mediation, it's really adjudicating on a very serious offense in the instances, where this has come up. Okay, so that is on, and then the other thing I wanted to point you on, staying on the point about process, is if we go to page 6 of our submission, where we talk about the physical access to the tribunal. We just have in here that we recommend another division in the western part of the island, and perhaps using technology to facilitate remote access. On the process and procedures, which is still staying on page 6, we have recommend consulting a number of sources. Ms. Pat Francis, who's here with us, and her team from her work with UN Women, they've done a ton of work all over the world on this, and they contributed greatly to our submission here. We leveraged a lot of their resources, which we have in the appendix that we've submitted, as well as footnoted here in the submission. And we think that we can gain a lot from just looking at that and seeing what's applicable here. So we believe actually that the process and procedure should be built out more relating to access to the tribunal. And finally, on the process, on page 7, you will see on the prevention measures, the last row there, the Act doesn't really mention as much yet about prevention measures. And we really want people, to understand what it is to, potentially be a perpetrator of sexual harassment, and certainly people to understand when they're a victim. So we believe if we do more training as a routine in organizations and settings, it would reduce potentially the incidents. So that's on section 2. That's on theme 2. On theme 3, which is a statute of limitation, I will point you to page 2 of our submission. Page 2 of our submission. We too believe 12 months is not appropriate for the period. We had a very fruitful and lively discussion in our working group on this point. We do recognize that it is a point that can have varying views. However, we have to consider in instances where this has happened, survivors of sexual harassment are often traumatized for a considerable period of time. They usually are trying to take themselves out of the setting before they report. And as we had discussed earlier, I do agree that the bill does have mechanisms in here, not just the Act, but also the operationalizing of it through the tribunal, etc., to ensure that cases that don't have merit are not successful. We are actually recommending that we follow the same time frame as for civil cases, right? So that time frame would be up to 6 years, if I'm not mistaken. Is that right? Up to 6 years? Okay. Just seeing who's nodding their heads and who's not. Right, so we were thinking up to 6 years to mirror the period for tort claims. So that's on the statute of limitation. And then finally, on the awards and powers of the tribunal, that theme on page 3, you'll see where in section 34.1, we just think that there should be more specificity. We tried to offer some suggestions, letter of apology, perhaps the greater of 2 years of salary or 2 million, etc. We just think that that should be more specific. So that really covers the bulk of the deliberations that we had as a working group and our submission here to the Joint Select Committee. Thank you.
Thank you. Is this a full presentation or anyone on the team wants to add anything?
No, that's it. We'll take questions.
Okay, good. Thank you so much for your presentation. Very broad, very comprehensive. Who wants to lead off with the questions? Senator Gale?
You asked the trade unionists in the room to treat with the employers. I want to deal with in terms of your scope now, because under definition of institutions, it highlights the varying areas. And when you look at your scope, I want to particularly look at capturing the alleged perpetrator coming from the report. And I can understand you capturing someone at the workplace, at an institution, tenancy, maybe even the church, because you have members in the church. But when you widen the scope now to public transportation, taxi depots, clubs, sporting events, a spectator, how do you seek to capture that alleged perpetrator to bring them to the tribunal? Okay. That is my question in terms of how you treat with scope.
Okay, I'll take.
Oh, Gavin, that was your submission.
Come on, Gavin.
Just press it though. You want to try this one?
Oh.
They don't want to talk at the same time. I'm not sure that there would be a distinction necessary from what currently exists in a workplace environment or in the institutions mentioned in the definition section. And if we were to be broadening it into an area where we're trying to offer greater protection in, let's say, even in a trade union or a political party, let's say. In terms of the capturing, that word suggests something almost of a law enforcement nature. Really, the matter here is one of the jurisdiction of the tribunal and its power to compel attendance of anyone. Because whether you are in the boardroom or you are, a loaderman at the transport center, the tribunal would have and should have the jurisdiction to be able to compel your attendance to come and answer to a complaint which has been made against you once they find it is sound. So I don't really think that really would be a major hurdle, unless I've misunderstood what you are asking, Senator Gale.
So, you see, it's just a question of placing an authority on the legislation to be able to bring these persons to a tribunal who is the perpetrator. You see, it's easier to treat with those who are assigned to either an institution or a workplace. But as you said, a loaderman out of half a tree who might be a known aggressor, there might be another legislation that we have to deal with that, rather than bringing an harassment cause to a tribunal. So that's my concern.
I get what you're saying.
And I know that the PSOJ and the Jamaica Employers Federation, who we are yet to hear from in this particular matter, would have raised the concern regarding a tribunal award. And I notice it would not escape the PSOJ from making representation here. But would you be proposing to have a schedule attached to this legislation? You spoke about apology letter and a cap, but is it a recommendation to have some sort of a schedule that, depending on the nature of the allegation or the gravity of it, what's the recourse?
Right. In terms of a schedule, not necessarily a schedule, but certainly in the act, whether it's in the body or in a schedule, we do think it's necessary for you to give and be very precise about the powers that the tribunal has. In the same way that the tribunal that you and I normally appear before, Senator, there's a list of things that they can do, and they don't have a power to make any award that they see fit. We think that to give that kind of power to a tribunal of a statutory body, it's not a court, they don't have any inherent jurisdiction, they would really require some greater specificity and guidance in this. So if what you're saying by means of schedule, if you mean a list, yes, we definitely do think that it needs to be listed, and they can essentially go through and say, this is the award that I think is most, or the remedy which is most appropriate in these circumstances.
That's me for now.
Thank you. MP Siblings?
Thank you. I'm still where Senator left off with buses and taxis. And vendors, I'm trying to understand the how it would fall within the Sexual Harassment Act, being that when you talk about buses and taxis, you don't have the persons necessarily traveling or is affixed to a particular transportation or is assigned to a transportation every day. And so in terms of any system outside of other acts that would take care of assault, you know, I'm trying to understand what was the thinking behind the PSOJ when it put these different classes, vendors, receipt of goods and services, buses, taxis. Assist me, please. I can understand churches and other institutions and the Rotary clubs and so on, because that is a place where we belong. We go there and we are a part of, and it's our culture, and so we want to operate in these spaces without being harassed by the president or the pastor or whoever who is in authority or seems constructive authority. But what is it with regards to the taxis and depot and the vendors? Explain for me, please.
Thank you, MP Sibley's, for that comment. So our premise, our starting point is that we believe any man or woman in Jamaica who can be sexually harassed should be able to utilize this act to be able to take the case where it needs to go, to the tribunal. And that's why we believe that a process should accompany this act or be embedded in this act that's specific around persons who don't belong to a group of an institution or a workplace or a group of persons, where you have that governance structure and communication structure in place where you can do that. We believe that in situations where people are taking public transportation and the act is happening multiple times, that they should be able to report directly, go directly to the tribunal, and it should not be limited to persons who have the privilege, I guess, of being at a workplace, an institution, a church, a club or association. It really should be for any Jamaican who believes that they are a victim, man or woman, of sexual harassment.
I concur with the principle of what you're saying. The difficulty I'm having is how do a tribunal, police, or supervise, let me not use the word, supervise and get persons to come to a tribunal, which it's more a civil jurisdiction rather than a criminal jurisdiction, where you have the police or whatever enforcement authority to get these persons before the court. So I am with you on that, on your principle that anyone who is harassed should have remedy. However, I am thinking that there are other acts that exist that persons can bring forth those persons before the court.
Thank you, MP Sibley. You want to make a comment? Go ahead, Mr. Goff.
Thank you. In terms of the harassment component of it, as far as I know, this is the only law. So yes, if there is an assault, you could use another act. But the challenge, which I appreciate fully, is that it makes no sense, whether it's a court, a civil court, or a tribunal, to make an award, let's say for payment of money, against somebody who is unlikely to be affected, let's say, by an order that you should pay some money. So that's the problem which you would have, whether it's the court that was doing it or a tribunal. The fact of the matter is that the remedy, and that's where the drafting comes in terms of the actual list or the schedule that Senator Gale was speaking about. So for instance, perhaps there could actually be a remedy where the person who has been found to be sexually harassing someone else can be ordered to be excluded from any government property. So let's say the transport center. The tribunal can make an order that nobody can go inside the transport center if the tribunal has ordered that that person should be excluded from that area. That could be the type of remedy which and that order in itself could be enforceable in the same way that a court order is enforced by the police if necessary. So it's not so much necessarily how you bring them to the tribunal, it's what is the enforceability of what comes out of the tribunal and how that will therefore change their behavior going forward.
I agree, and I understand the concern because I represent employees in a bank that interfaces with customers. And a particular business has an harassment policy. And we're saying to them, including that harassment policy, the protection of your employees who have to interface with a customer. Now, banks don't want to turn away customers. And so you have this situation where we have seen where customers who have big bucks and are clients of businesses that comes in and harasses the employee. Mm-hmm. And so there has to be a position taken by an employer to protect its employees against known harassers. Mm-hmm. And treat with them.
Absolutely.
And this is where this piece of legislation, Chair, maybe have to be explicit somewhere in that nature. Because there are persons who are not aligned, not attached to these, either the institutions or the workplace, but there are suppliers, there are customers who are known perpetrators. And so there has to be something embedded that protects those of us who are part of these institutions against those aggressors.
Thank you. MP Brownberg? Oh, I'm sorry. I'll take MP Brownberg, and then I will come to you.
Thank you very much, Madam Chair. I first want to say that I'm impressed by the obvious depth in terms of the analysis and the time spent in looking at the issues and presenting the solutions. There are three issues that I wanted to raise. Two very simple ones. I'll deal with those first. In the written submission, there was a proposal to delete 34(1)(c). You didn't speak to that, and I was just wondering what was behind. That's on page 3, is it, of your, right, as one of the remedies. I just wanted to understand what was the thinking behind that, just so I understand that. So that's one. The second one has to do with, I think it was the composition of the tribunal. I can't even find the page. I just know that in it, the first line that struck me was that members should be non-partisan. And because I feel so strongly about it, I wanted to speak about that. One is that Jamaica is a very small country. We have, for many years, had a system of a two-party system. there are some obvious partisans, those individuals who are in Parliament, those individuals, either House of Parliament, etc. But I have found that the more rabid partisans are those who never claim to be. Therefore, I am not sure what is behind this notion that members should be nonpartisan. I notice there's no call for members not to be police, not to be from the church, and other institutions. And maybe because I believe for too long in Jamaica, we have accepted this notion that those of us who have chosen to serve our country through political parties are less than others. And therefore it bothers me. I'm going to be honest, it bothers me, and it bothers me immensely. We do. And so I object to it, in the most strenuous of manners. And I wanted to just kind of place that on the table. And then the other is around the notion of public spaces, the scope of the bill. And those who know me know that I am one of those that wished the bill actually had jurisdiction in public spaces, far more, than the bill currently does. So I must say that I admire the creativity that went into identifying some other institutions and places like the bus depot, like the taxis and those, that would allow for greater coverage. Others during the last session had come before us and actually presented data that showed that a greater percentage of sexual harassment did take place in these settings. And therefore, what the bill covers is really a smaller percentage of the individuals who are harassed. So from that perspective, I'm going to be honest, I like that. When we were talking about it and trying to find ways of persuading others to include it, I didn't certainly have that kind of creativity in coming up with those pieces. So I like that is there, and I would want to ask the members of the committee not to throw it out without due consideration.
Thank you, MP. Mrs. Maya Johnson, you wanted to make a comment. Please go ahead.
Thank you, Madam Chairman. Just following on this point about the scope of the law, I think it's useful to point back to our definition of sexual harassment and the point 3, that it includes a sexually hostile environmental condition. And that's where we felt that it needs to address more than just workplace, because the reality of our society is that we are often in environments which are public spaces and subject to sexual harassment. We have a culture that has embraced this idea of it's okay, it is desirable to sexually harass people, and we felt that it was important that this particular act recognized the cultural context in which we sit. And we also looked at the best practice in other similar countries and environments, such as India, where public transportation has been one of the main places where particularly women and girls have felt under threat. And we do recognize that places like public transportation are licensed operators giving a public service. And so we do feel that it is appropriate for those kinds of environments for the standard to be very clearly set that it is not okay that sexual harassment can happen in those environments, and that as part of being licensed as an operator, that there is an expectation that you understand what sexual harassment is, you understand what is expected of you as a provider of a public service, and that there are consequences, right? And so we really feel it's important that people in our society who have no choice but to use public transport and who in fact often do encounter the same providers over and over because they have to take a bus at a particular time or they have to use a particular taxi route, feel comfortable that this act protects them as well. So I just wanted to add that.
Thank you. I'm going to recognize Mrs. Patricia Francis and then Senator Gale.
Thank you very much, Madam Chair. I just wanted to support what was just said by Mrs. Johnston. Critically, that this bill will exclude the majority of the people as it is currently constructed. Because as Mrs. Brown-Burke has said, the majority of sexual harassment happens in our public spaces. And as such, it limits currently the remedies that the majority of our people will have for sexual harassment. Secondly, it's important again to reiterate that this is about culture. And the only way that we are going to transform culture is by public education. Public education starting all the way from schools all the way up. And critical to transformation of behavior. Again, we don't speak about in the bill how we are going to have preventive measures. And that preventive measures should, in fact, not only look at the workplace, because of course there is a whole slew of proposals that exist, best practice that exist, that one can look at for the workplace. But there are also very good best practices that have been seen in looking at how you transform how public transportation works, how public spaces works. In fact, UN Women is currently just signed an MOU 2 weeks ago with the UDC on looking at how we transform public spaces and have better safety in public spaces for sexual harassment. So I think my plea here is that we don't discriminate against the people who are least likely to have the level of support that we're talking about. When I listen to what is being said about how we represent ourselves in a tribunal, how many people are going to have that level of support going into a tribunal that are currently being sexually harassed? So, you know, you can take a low-level worker in an institution. That person does not have the same level of support. And again, I think this bill needs to speak to the kinds of support that are necessary, both in the workplace and also publicly, for those people who don't have the kind of resources in order to go before a tribunal and put their case properly. So my plea is for the majority.
Chair.
Thank you, Mrs. Francis. Senator Gale?
Yeah, you see, I wholeheartedly agree with an objective to eliminate or to eradicate sexual harassment anywhere. Define what takes place in India in terms of the public transportation, but how do we get them, in this case, to a tribunal or, you know, to address these matters? There are some that have to treat with a licensing authority, so maybe the transport authority, that might be the designated area in treating where that grouping lies. So it's really for the technical persons now to assist us in how we can craft a legislation that is seeking to widen the scope that is being represented here today.
Thank you, Senator Gale. I want to invite a member of our technical team who may want to make a comment. I see Mrs. Celia Brown and Ms. Georgette Grant looking at each other. Who am I recognizing? Miss Celia Brown.
I mean, it's food for thought, Chair. I'm thinking if we are going to deal, I was just checking to see if other jurisdictions had done anything, and I'm seeing some street harassment prevention legislation coming out of the US. So the committee can look and see how we can, whether we would need separate piece of legislation to deal with street harassment, whether we would criminalize that type of harassment rather than just provide for civil liability like we are here. It's something that the committee will have to consider, Chair, when you meet to deliberate.
All right, thank you, Ms. MP Cousins. Yeah.
Thank you, Madam Chair. While I have been listening, and first of all, I want to, Mrs. Robinson, thank you for a thorough presentation. And I like the fact that you came today and you actually came with some valid recommendations, some of which are eye-opening. For example, 6 years as opposed to 12 months, consistent with the 6 years of statute of limitations for offenses, civil offenses. So that's a recommendation which I agree with totally. And I understand the need to widen the scope of persons who may fall within the remit of the tribunal to ensure that, for example, persons in public spaces are not excluded, but it is important to also remember that this act doesn't preclude someone, for example, from going to a police station and making a report. And there are other legislations out there that treat with instances where persons, if they are touched in an inappropriate way, they can go to the station and make a report, sexual touching, for example. I understand the need to widen the scope, but I think we have to be careful. And so what Senator Gale is saying, I believe, is very important. And look at the Memorandum of Objects and Reasons. It speaks to some relationship, whether it be employer-employee or institutional. And I believe that this particular legislation is more focused on that, as opposed to incidents that take place in the public space. Whilst we accept that in the public space, sexual harassment does take place, we must understand that there is simultaneous legislation elsewhere where persons can either go to the police and make a report, and there's also, not for harassment, but for touching, for example, for touching. Because one of the problems we're focused on is harassment is just about words, but it's not only about words, it's not about what you say. Sometimes about touching, etc. But as far as my understanding goes, and I'll take some more time to look at legislation, but I believe it is dangerous for us to go too wide with the legislation. And so, whilst I accept a part of a presentation as it relates to the 6 years extension, I don't know how far we can go. A church, for example, a political party, those are areas that could reasonably fall within the scope of the legislation. But there are certain areas that will not fall within it, and it will be too difficult to police. And that is the challenge. Thank you very much.
Thank you, MP Cousins. Cecilia Brown?
Yeah, just to add to what was being said, I notice in some of the legislation that I'm looking at, they actually, it looks at certain areas and it defines in one particular act a high-risk area. So you limit it, even though it speaks of street harassment, it is limited to certain areas. And you think places like the bus terminal, you have the food service entity, a school, a library, bank, healthcare facility, retail and stores. So it limits even in speaking of street harassment to certain high-risk areas. So that is something that the committee may want to look at and consider when we deliver.
Okay, very good. Thank you so much. Well, I think we have, our members seem to be quite satisfied with their presentation and the responses that they've had to the questions they've raised. And I really want to thank you for coming and to indicate that what you have put on the table will be looked at and taken into consideration during our deliberations. I invite you to remain, if you so wish, as we take the final presentation for the day. And that is from the Jamaica Tertiary Education Commission with Dr. Damian Black and Mrs. Tracy Ann Singh. So we ask you to proceed with your presentation. Thanks.
Thank you, Chair. Good afternoon, everyone. Chair, we certainly appreciate the opportunity provided to us. As an agency of the Ministry of Education, Youth and Information, with particular function in the regulation oversight of tertiary education institutions. And I also would like, through you, Chair, to just express appreciation to the staff here at Gordon House who assisted us in appreciating and understanding exactly what it is that we might do in making this submission. We make 10 points in this submission, focused on particular sections, and the first, as read and understood, looking at section 4.3D, which speaks to the internal mechanisms and procedures that are available to a worker, student, etc. The issue or concern that we have with this particular area is having to do with the requirement for the policy statement that is mandated of organizations, institutions, to include a detailing of the internal mechanisms and procedures that are available to someone who is accused of sexually harassing someone. And indeed, a recommendation that we would make here was that the demand for a policy statement might include internal mechanisms and procedures available to someone who has been accused of sexual harassing a worker, student, resident, ward, etc. The rationale really has to do with just general context within which our critical focus, students and other stakeholders within higher education institutions, and the extent to which certainly whilst victims, persons who complain of being sexually harassed, but also the perpetrators, administrators, support staff, and the critical care workers who would be required to facilitate and support such a system. We think that critically, we want to ensure that the critical principle, which is the need to deal with sexual harassment, is not rejected simply because it is not seen, neither is it that the procedures, the regulations, etc., within an institution are accessible, clear, accurate, and fair to all persons, including those who might be accused of it. The second item, section 4.3C, there's a statement here, a statement to the effect that disciplinary measures as are appropriate shall be taken against any person under the direction of the employer or the person in charge of the institution. The issue of concern to us is this. We certainly would have to assume, unless guided otherwise, that the reference to any person under the direction of the person in charge of the institution is a reference to someone employed to the institution. As such, we note that critically, one of the areas that has to be considered is student-to-student interaction, particularly within the context of the higher education space. And thus the question arises, the extent to which students are deemed to be under the control of the person in charge, given the various interactions where they might arise, etc., and the various cultures, subcultures within institutions. And so again, we just make a recommendation that consideration could be given to adding a section about disciplinary measures as are appropriate shall be taken against any worker, student, resident, ward, etc., who sexually harasses another person, to bring that dimension of the student-to-student interaction as opposed to the power dynamic, which is very obvious within the bill. One of the things that we referenced, as seen in both the initial submission and then this PowerPoint that was highlighted the aspects of it, is some guidance from universities UK and the whole need to just publish this code of conduct that is broad and establishes the duty of care to all persons within an institution's remit. The third item, having to do with section 4.3H, the wording is a statement to the effect that a person who is a victim of sexual assault. It's just having to do with the use of the term victim in that specific section, that is section 4.3 CH. Again, to us, the idea, well, one, in the previous section F, it speaks about complainant, but then it moves at this point to victim. And the language or notion of victim, again, just making a recommendation that perhaps that might be shifted to continued use of the term complainant as opposed to victim, because it speaks about a victim going through the entire process within an institution, and until it has ended, the notion of victim would suggest that, you know, that has been defined, it has been accepted, the charge has been proved, and as such. So we just like to recommend, again, that the notion of the term complainant replace victim at 4.3H. The fourth point that we would wish to raise is this. An employer shall take immediate and appropriate action where the employer becomes aware of the sexual harassment. This is Part 2, Section 5.1, and the similar wording, but with directly referencing the person in charge of an institution. The language seems to be suggesting that when the report is made to the employer or the person in charge of the institution, then the report is to be treated as having occurred, as opposed to it triggering a process that should be followed to determine what transpired. And as such...
Which one is that?
Part 2, Section 5.1.
Section 5.1, thanks.
And also at Part 2, Section 6.1. 5.1 deals with employer, 6.1 deals with the person in charge of an institution. And so a recommendation would be to treat that in terms of possible wording such as where the employer or person in charge of an institution is made aware of or receives a report of sexual harassment, as opposed to where the employer becomes aware of. It has to be proved. So that's really just a point there. The fifth item or point that we'd wish to raise, Part 2, Section 6. Okay. The employer or person in charge of an institution may have acted in response to a report or reports of sexual harassment and acted in keeping with the published policy statement. However, the complainant may be aggrieved at the outcome. If the outcome of the process results in an adverse finding against the complainant, and again, the context is within an institution, is it that the process ends there? Is it that the complainant is prevented from taking the matter further, to the extent to which he or she may not feel justified that the appropriate measures have been taken? And so the language to us would seem to suggest no, but then perhaps a triggering to the tribunal might be allowed there. Sixth point, Part 2, Section 6. It has to do with the general notion of recourse for the accused who has been cleared, or where it is that the complaint against the person has been or not been proven or supported. And so the consideration of recourse, this has to do not necessarily at the level of the bill, but certainly institutions within the guidance through the law or the regulations in support might be asked to establish procedures that treat with this. The seventh item has to do with a concern that we have, is that there is no stipulation for the employer or person in charge of an institution or organization to ensure that accurate and complete records are maintained and retained in keeping with legal requirements or the issue before the institution in terms of this charge. Again, the best practice as developed within our counterparts in terms of the ones we looked at, the UK, Australia, Canada, other Commonwealth jurisdictions, indicates and demands that these records be maintained to ensure that there is what is called a systematic recording procedure. Indeed, beyond the institution or beyond the organization, if it goes to the tribunal or if it becomes another legal matter, then these records are going to be quite critical. There's another aspect of the records, Chair, that we'd also want to point out. The we do not know, given didn't have access to the full thought behind the formation of this bill or the extent to which records would be desired. But we know that tribunals would keep records of cases before it. But the extent to which institutions, though, are mandated to maintain records of all cases, not just those proven, but any complaint at all, so that this might inform the nation generally, policymakers, as to the nature and incidence of sexual harassment. 8, perhaps a minor point, but the Part 4, Section 10.1 does speak to the minister with responsibility for gender affairs may designate persons being field officers attached to the Bureau of Gender Affairs as authorized officers, etc. The issue that we raise here is why the specific mention of this bureau. Why is it that we know that it is the agency responsible, but perhaps as a by way of a recommendation, the reference might be to an agency with the responsibility for gender affairs as opposed to the specific entity, which exists now, this is the legal name, but it may change in the future, and so to constrain the bill with such a specific reference. 9, there's a statement at Part 6, Section 28, pursuant to a report submitted by an authorized officer under Section 27.5, where the tribunal finds that there is no evidence of sexual harassment. And again, not being a lawyer, but we did have some conversations with one in particular on the whole notion of this matter of evidence. And it somewhat may be impacted by the earlier discussion about the frivolous or not, and then the fine attached to a claimant or complainant, sorry. Certainly we recognize that evidence must be at the base of a finding that sexual harassment has occurred. The question that arises is, might there be evidence or indications from the evidence or statements presented to the tribunal that although not allowing for a finding to be made, would suggest that the charge cannot be sustained, as opposed to not finding any evidence. And so perhaps language that would speak to, pursuant to a report submitted by an authorized officer under Section 27.5, where the tribunal finds that there is no evidence of sexual harassment or that a charge of sexual harassment cannot be sustained. Part 6, Section 31.1, the tribunal may, for the purpose of a hearing by notice in writing, direct any person specified in subsection 2 to attend at a time and place specified in the notice for the purposes of the hearing. The issue here, Chair, the section appears to be mandating physical presence. Outside of COVID-19, which has affected, and I know that the court system has attended to this, but certainly this has to be remain in our focus in terms of an epidemic or pandemic. But it's the issue of the power dynamics, power imbalance, and the extent to which, as we note, that remote attendance in a place and under conditions that satisfies the proceedings of the tribunal would allow complainants to appropriately deal with matters of power imbalance. I would close just by making reference to a situation we faced at the agency through a student who actually reported that she was sexually harassed in our facility. And she made the report, spoke passionately about it, and pointedly, very angry. But after a while, when he said, okay, please document it, she withdrew. A few months after, she again came back with the matter. I said, listen to me, just get this thing in writing, because we not only the duty, but also to protect ourselves. And she made the report. We got it, and we were about to prosecute the matter. Sorry, I shouldn't say prosecute, deal with the matter. But when it was that we were at that point, she again withdrew the claim. The power dynamic, me against, and what obtains is a very critical issue. And so, to the extent that not mandating physical presence in all instances, especially where there's concern on the part of the complainant with respect to the power imbalance or power dynamic, if it is that facilitating their participation in the process of review through remote means, through technology, then certainly we feel that that might assist to minimize some of the issues, including the one that I just mentioned. So essentially, those would be the critical areas that we want to highlight.
Thank you. Thank you, Mr. Black. Ms. Singh, she has any comments to add? Okay, that's very good, very detailed, very precise. I don't know if our technical team has any comments regarding some of the, Mrs. Coburn Robinson from the Bureau of Gender Affairs.
Thank you very much for your very comprehensive presentation. I'm just picking up on a few points you raised concerning the naming of the entity. I do take the point, because you rightly pointed out that the name might change, and in fact it should change. So having the term agency, responsible agency, would be okay, or entity would be okay with us. I also wanted to speak about the case you raised, case in point, when you mentioned that there was a case of sexual harassment and it was dropped twice. So in the section that speaks to tribunal, that's section 27, there is provision for field officers, persons who would actually go out and take the case, listen to the person, have the person explain and so on. I think that where that is concerned, that would help in this case, where this person might feel intimidated or traumatized, or just feel inadequate, intimidated and all of that. So the provision under the tribunal will allow for those persons who have training in social work and psychology and so on to be able to speak with the person, and perhaps through that kind of support, that might allow for less cases to be dropped. And there was one final point I wanted to make. You've mentioned the reference. The piece about the agency responsible, that's fine. There was one other piece earlier when you mentioned the person responsible at the entity in terms of making sure that they are accurate and complete records. So in terms of this legislation, it speaks to the responsible person who is in charge, ensuring that the records are done, the writing is done, and that there is a comprehensive record of what has taken place, and to note if there are persons who were aware of it. For example, if you can have persons to validate your claim and so on. And that person has the responsibility of ensuring that all members of that particular entity are aware of a clear policy that states their take on sexual harassment, and that's going to be in line with the legislation itself. The Bureau, through the ministry, has the responsibility to ensure that each entity has a clear policy, and where there is no policy, then the reference is made to the legislation itself, and support is provided for that. And once it is clearly stated from that position of the vantage point of the person in charge, once a case comes up, then all persons in that particular entity would already know. And if they didn't, certainly that would be a point where the information could be shared in terms of the position of the entity on sexual harassment in line with the Sexual Harassment Act, which of course, based on all the discussions we've been having and all the submissions, at the end of it, I'm sure we're going to have a very comprehensive bit of legislation. And I must say that earlier persons had spoken about where we are now. I must say that this is a far way from where we started. And at this point, there are so many additions and provisions that have been included to ensure that it is more comprehensive. So I do believe that I take all the points you raised, and I think that there's worth in including some of what you've mentioned, and to make sure that at the end of the day, we have a very comprehensive legislation. Thank you.
Thank you, Mrs. Robinson. Senator Gale?
Sure. A very detailed presentation raising some, what I consider to be some procedural areas. I was trying to quickly scour the bill when you made reference to the term victim as opposed to complainant. And I was trying to look in the bill if the term victim was used, or if it was used, it was not defined. And if it's done interchangeably. So that's something that we need to look at. You made reference to section 5 and 6 that speaks to the employer shall take immediate and appropriate action, and a person in charge of an institution shall take immediate and appropriate action. So what this is seeking to do is to ensure that the employer or the head of the institution takes responsibility. Yeah? But one would have to again determine what constitutes appropriate action. And so maybe the suggestion that came to my mind and has been put forward before is that this is a piece of legislation that is seeking to change behavior. And when you have those types of legislation, it is going to require some code of conduct or some guiding principles so that an employer or a head of an institution will directly know how to respond when they are taking responsibility. Because if they fail to take responsibility, then they are going to be facing consequences. So it's important to highlight that code or guideline that would allow them to understand and appreciate their scope of permissiveness. The other area that I want to highlight, Chair, which I believe is a key point that I'm trying to look if it was addressed in the legislation. So an employee, you have a complaint, and the employer would have gone through the internal mechanism in treating with it. And so the finding might not be one to which the complainant accepts. So we have to determine whether or not contained in this legislation is a trigger to escalate it outside, and what would be that remit or route in escalating it outside of the internal mechanism. Because what you want to ensure is that justice appears to be done, and in the final analysis.
What must be done, though?
Yeah. Well, let's deal with the appearance first. Right? So you may have situations where a complainant still feels aggrieved and may very well want to escalate, and we have to ensure that the bill makes such a provision for the escalation. But I think that was a key point. Thanks, Chair.
May I just say a quick word?
Thank you, Senator Gale. Minister Chuck?
I think, you know, Dr. Black has a very good point in terms of, we have made it one of the procedure to put the complaint in writing in section 25. And so we put may, subject to subsection 3, make a complaint in writing in the prescribed form. I think we could easily remove the in writing because it says make a complaint. It could be in the prescribed form. I don't think every complaint has to be made in writing. In other words, you could make the complaint to the, whoever, the tribunal or someone else, just like happens in most police stations. The police officer is the one who puts it in writing. Because there are many persons who may not have the capability or feel like putting it down in writing. It doesn't come out proper. So I would say that, Mrs. Steeler Brown, one of the things, I will remove that thing, make a complaint, right, and remove the words in writing, so that it could well be an oral presentation captured or a video captured, you know. So I think that's a very good point, because especially sensitive victims and may not feel like they could properly craft it in writing, they rather put it orally, okay? Or otherwise, yes.
Well,
Chair,
there are no further comments.
Chair, could I just
yes,
to
Mr. Black.
Senator Gale. The point I was making about 5.1 and 6.1 was not that there shouldn't be procedures, but rather the implicit understand, well, it seems to me explicitly, they says where the employer becomes aware of the sexual harassment. Does a report equate to the fact of the allegation? So in other words, when the employer or the head of the institution receives a report of sexual harassment. So,
having received the report, that should have been the trigger that you become aware.
Precisely.
Okay.
So as opposed, because it does say that where the employer becomes aware of the sexual harassment, but it hasn't been proved, it hasn't been reviewed. So that is it. This is the language.
Once you receive information.
Yes, you act on it.
Yeah.
Thank you. MP Rhoda Crawford.
Thank you, Madam Chair. I just want to make a general comment on all of the presentations. I believe that they were very insightful, very detailed, and I know for me, I will be paying closer attention in my own time on details of the submission. I believe that we all have one common goal, which is to ensure that the bill protects the interests of our Jamaican people. And I think that it would be very useful for all of us to pay close consideration to the submissions so that we can revise the bill to the satisfaction of all concerned. Thank you.
Very good. Yes, Mrs. Francis?
I just wanted to make a quick comment on procedures. UN Women Legislative Handbook has many procedures in there, good practices from different areas, and I think it's an excellent reference that we could use to look at procedures. So just one small comment.
Thank you. Ms. Singh?
Through you, Chair, if I may, on the note of procedures, just to inform the committee through you that through the work of the Jamaica Tertiary Education Commission in collaboration with the Jamaica Union of Tertiary Students, we have actually embarked on developing a guideline to address safety and security across our higher education institutions. And student harassment and sexual assault is a key component of that. So I'd like to thank the work of your committee in putting together this bill, and we'll be using this bill to inform the development of this guideline document.
I really want to thank you, and in fact, I should let the members know that the Jamaica Tertiary Education Commission, they were watching our deliberations on maybe PBCJ television, and they reached out. They showed the initiative to reach out to us to indicate that they wanted to make a presentation. So we really want to thank you so much for an excellent presentation. And we will certainly take into consideration the points you have raised. Members, all the presentations that come to us will be put on a matrix for us to, to have a clear picture of what each presenter, what each entity is contributing to the deliberations in order to come up with the right piece of legislation in treating with sexual harassment. And after we have received all those presentations, we've prepared the matrix. As members, we will now have an opportunity to examine and to make the decisions, and then to take that report to Parliament. So I'm very confident, based on the interest that you have shown, that we are on the right track. So we have not concluded our session, but we have concluded the presentations. And Ms. Francis, thank you, and just thank your colleagues, thank you, right, for making presentations to us. Thank you so much. Now, I had moved a little ahead of the agenda here, just to take the presentations and to allow the presenters to leave so we could do a little housekeeping. So if you go back now to your agenda, where we have the following items. 2, right. So, item 5A, we have to move the adoption of minutes of the Joint Select Committee, the Sexual Harassment Act 2019, for the following dates: November 28, 2019, January 29, 2020, February 5, 2020, June 18, 2020, June 25, 2020, and July 2, 2020. So I'm asking for the adoption of the minutes for those dates. I seek members to
Maybe it's only 3
for
of
the
us can do
adoption.
that, so I so move, Chair.
Moved by Senator Gale, seconded by Senator Longmore. Thank you. 5B, for the adoption of submissions received by the Joint Select Committee Sexual Harassment Act 2019. As stated previously, we ask for the adoption of those presentations. Those submissions, rather, yes. MP Brownberg and Senator, seconded by Senator Longmore.
Am I to understand that we have now exhausted submissions, or we still? That's it. No. What I mean, for those who have submitted already, right? Not for presentations now, you know. For those who would have submitted. Okay.
Those have submitted already,
All right.
yes.
There's a particular reason why I asked that question, but leave it at that.
And then for item 5C, confirmation of the minutes dated October 29, 2020. Right, for this new committee, right? So who, Senator Rodriguez Campbell, seconded by MP Rhoda Crawford. And so now we go to matters arising from the minutes of October 29. If, you know, I'm assuming you have had a chance to read the minutes, and if there are any matters arising, if there are no matters arising, then I would, no matters arising. All right, thank you. Okay, so we have just about completed the agenda, and now we'll ask if there's any other business. Anyone has anything to raise? I just want to reconfirm our meeting schedule. Next week, Thursday, same time.
So will we have submissions for them, Minister? Will we have submissions ready for them if we have exhausted?
Oh, no, we do have.
Okay. Right.
We do have sufficient. You have a list? We have about how many? We're working towards having 3 presentations next Thursday, right? And then the following week, we will also meet. So I really want to thank you all. I want to thank the technical. Go ahead, Mrs. Robinson.
Thank you, Chair. I just wanted to let persons know that next Thursday, November 19, is being observed as International Men's Day. So for those who are not aware, it is International Men's Day.
Ask all the ladies to give the men an applause, a round of applause in advance. Will we have a special, Mrs. Robinson? What happens, members? Let's ask Mrs. Robinson, who is head of the Bureau of Gender Affairs, what is being planned for the men on International Men's Day?
So thank you very much, Minister, for asking. There are a number of things that are being planned. The theme is a man's health is a man's wealth. And so most of what we're doing, and I know that Senator Safai is very excited about that because she loves to talk about health, especially mental health. We will be having a number of presentations for our men, unpacking the health issues, different health issues. We'll also be having awards. In June, Minister, if you'll recall, we had selected some men who were outstanding fathers in the month of June when we observed Father's Day. But because of a number of reasons, we did not get a chance to make those presentations. So those will be done on the day. We will also have short panel discussions with specialists in different areas, health and otherwise, who will be speaking on different topics. So we'll have concurrent sessions. And we'll also have some boys who will be coming into mainstream. We have a new program that was launched last year. It's positive, the Male Mentorship Program, and there is the Mentor Me 2020, Young Fathers Initiative. So those, we will be giving updates on those on the day itself. And is there anything else? I think all in all, based on what we're having, because of COVID-19, we're not going to be able to have a lot of persons in the space because we have to do the social distancing. So we'll have live streaming. So persons will not miss out because they're not there physically. They'll be able to have a chance to be beamed in via Zoom or whatever other platform they wish to be. And we'll have a church service. I should have said that first. That's this Sunday coming at the Constant Spring Road, Church of God, starting at 9 a.m. 20 persons in the room, so the other persons will get their link, Zoom link, so they can also be a part of it. And I think that completes it because that's quite a lot based on the fact that we have to do social distancing.
Right, thank you so much, Mrs. Robinson.
You're most welcome, Minister.
The Bureau of Gender Affairs is not only about the women, right? We are looking about the men as well. Yes. All right. So I just want to thank you all for coming. And at this point, Miss Grant, you wanted to say something? No? Okay. All right. Thank you so much for coming. At this time, will someone move? All right. Moved by Senator Longmore, seconded by MP Crawford. Meeting is now adjourned. Thank you.
I am Paula Llewellyn, Queens Counsel, the Director of Public Prosecutions for Jamaica. We are in an era which focuses on all things technological. As such, material produced by all sorts of devices, including computers and phones, is increasingly becoming a central feature of criminal investigations. Good prosecutions are based on the fruits of good investigations. It is therefore critical that police officers who are engaged in investigations which involve the collection and examination of evidentiary material are equipped with the necessary tools which will enhance their capabilities in respect of securing the preservation of data and obtaining the production of the said data for court purposes. The Jamaican Cybercrimes Act of 2015 contains search and seizure provisions which are available and allow the police to enter any place named in the warrant to search and seize any computer material which would be reasonably required to facilitate and progress the criminal investigation.
Such computer material includes any data which may consist of video footage stored on closed-circuit surveillance systems, CCTV, or data stored on global positioning systems, GPS. Also, photographic images or any other material which may be stored electronically on any storage medium. It can also include call data records or cell site information, provided it is material which is stored electronically.
Firstly, and most importantly, police investigators must be aware that computer material cannot assist if it is not preserved at a very early stage in the criminal investigations. Preservation is critical. Computer material is transient. It can be easily deleted or rendered inaccessible to the police. Therefore, after carefully analyzing the crime scene and/or the allegations, investigators must seek to identify all items of digital evidence which may be useful in proving the commission of an offense or which may also